All right, well, I think we're all gathered. We're running a little bit behind, so I was just going to start off, just so you know we're all on the program. This is the AT&T Time Warner panel, seeing what the, in the aftermath of that decision and the expected appellate decision, how that might change things. I'm going to, because we really want to get to the discussion, I'm going to just give some brief introductions. I should introduce myself first. I'm Jeff Bliss with Capital Forum. And I'm going to go from this side to that side. So sitting to the far side is Angie Cronenberg. She is the Chief Advocate and General Counsel at Encompass. This is an organization of internet, streaming, communications, and technology companies that support competitive networks. Sitting next to her is Ross Lieberman, who is Senior Vice President of Government Affairs at the American Cable Association, which represents nearly 800 small and medium-sized operators. Next to him is Mandy Reeves. She is Global Co-Chair of Latham & Watkins Antitrust and Competition Practice and a former attorney advisor for FTC Commissioner Tom Rush. And next to me is Hal Singer, who has several job titles, is Managing Director of Econ One, a Senior Fellow at George Washington Institute of Public Policy, and an Adjunct Professor at George Washington University. So I think before we launch into the broader questions, let me just start off, let's start off with Angie. Perhaps you can talk to us a little bit about what happened last week in terms of the appellate hearing and what you think that the impact of that was, or what do you think might come out of that?
Sure. Thanks so much, and thanks for allowing me the opportunity to come back. I was here a couple years ago just as we were going through some major administrative changes, and one of the things that I predicted at that time that I think some folks were a little surprised by was our prediction that the Trump administration would really be focusing on competition issues across the board, and that it wouldn't be limited to one particular sector, but that the mandate was from consumers. We're really unsatisfied with how we're being treated. We're worried about the consolidation that's happening across the board. We're worried about price increases. And so, rightly so, I think we've seen a very strong antitrust perspective. The DOJ looking at these issues very closely. One of the mergers that I was first following immediately after Macon arrived at DOJ was a merger that involved one of our members, Level 3, with CenturyLink. And what do we see Macon embrace? Macon embraced the viewpoint that when you have companies with significant assets that are competing against each other, and in that particular realm, these are network companies. So these are fiber companies and copper companies. This is network that is expensive to build and hard to build. He required divestitures. And he required divestitures because he recognized that further concentration in an already highly concentrated market is problematic. So why am I talking about it in the context of AT&T Time Warner, right? You're probably wondering. Yeah. So in AT&T Time Warner, you have a combination of not just network assets. AT&T, a company that has significant wireless network, a significant fiber and copper network, as well as their acquisition of DirecTV, which I think really is the combination of those things along with its proposal to buy the Time Warner assets, those programming assets. Why is programming so important? I would say, how do you spend your evenings? That's why programming is important, right? How do you hook customers? And companies use programming in order to get their customers to switch to them, right? Like, come to us. And this is exactly what we're seeing AT&T do right now, post-merger. So, I think looking at the very limited, narrow view that I think the court was looking at, which is, do we defer to the district court judge that disagreed with DOJ's case, or do we look anew at this? I think it's really not that surprising that some of the analysis is suggesting that the court's really not going to do that. The court is likely to just confirm what the district court, found. Unfortunately, what the district court found, I think, didn't go as far and didn't really look at all of the issues that should have been considered. And, Macon was recently at our show, and that we had at the end of October and was talking more specifically about it and putting their case forward. And I don't like to second guess the experts, right? I mean, it's not my job to do. But looking at the issues here with respect to AT&T's size, its control over 3 different kinds of network assets, we have significant market concentration. We have large ISPs that have like carved up the nation. The majority of Americans only have one choice for their ISP at home. And now we have AT&T owning significant programming assets that they can use to lure customers that have a choice over to their network. So, this is, I think it's telling that when you have a court that's choosing not to enforce more competition, and then on the other hand, you have a regulator, and here I'm referring to the regulator at the FCC, that has largely abdicated its responsibility to oversee and ensure that there's significant competition. I'm a little concerned about what this means. As a competitive advocate, I'm a little concerned about how we're seeing the market shape up, both with respect to the ISP markets as well as with respect to the availability of programming, how that programming, independent programming, is going to compete when they're highly reliant on the delivery of that programming over networks that are already highly concentrated.
Okay, Al, do you agree? Does it look like, well, the appellate court might basically endorse what the district court did and all the repercussions that Angie was talking about?
Well, I'll agree with the first part of what Angie was talking about, which is that I think the appellate court is going to sustain Judge Leon's decision. And I should just say at the top here, I want to disclose that I've worked on various matters for AT&T over the years, but I was not involved in this merger. Unfortunately, they hired other economists for that. There was a key line during the appeal that I wanted to read back. One of the appellate judges said, quote, "You have to have numbers to make a model work," end quote. And to me, this really resonated. I think that the landscape, the antitrust landscape in terms of enforcing vertical mergers and just Section 2 cases in general is very hostile. And I don't think that this decision is necessarily going to make it any more so. I think the price effects here, if you just credit what Carl Shapiro said, was on the order of 20 to 40 cents per subscriber per month. And to put that in context, if your average cable bill is $100 a month, and you step 10 feet away from it, it almost looks like there's no effect. It would not be economically significant. And of course, if you breathe on the model in any slightest way, like for example, if you challenge the charter input on the departure rate and you take their original estimate of 5% instead of 9%, the price effects go to 0. So I'm all for pushing the limits of enforcement and vertical mergers in general, but I don't think this was the case to die on. You want to do this with a merger that is a mashup of a distributor with significant downstream market power. I'm thinking about a cable operator with, say, 50, 60% market share, and a must-have input. And there we have a few of them: broadcast networks, regional sports networks. I think here, in contrast, what we had was a distributor with a relatively small downstream share. It's satellite share, not the cable share. And then, and I want to apologize in advance, I think there's a CNN reporter here, and I say I love Jake Tapper a ton, but we're not talking about a must-have input. And so it should be no surprise you don't need a PhD in economics. When you put those numbers into the model, you get very, very small price effects. So I kind of figured that this was going to happen. I think Judge Leon said as much, and I think that the appellate decision is going to go this way as well.
All right. Well, one of the reasons, obviously, the DOJ antitrust chief, Macon Delream, brought the case is because he does not like behavioral remedies. And we can talk a little bit about your experience. You've had some direct experience with some of those behavioral remedies in this industry. Mandy, do you think that we're going to see perhaps a resurrection of the behavioral remedies as like conditions for these type of deals?
So I would say certainly indirectly, in the sense that if you look at Judge Leon's decision, part of the challenge for the Justice Department was that, unlike in a horizontal merger setting where if you can show basically a level of consolidation, there's a presumption of effects, here Judge Leon emphasized that he wasn't going to find a presumption. The DOJ had credited the elimination of double marginalization as a potential benefit. And so as a result, there really is a true burden on the plaintiff, and then in these cases typically the FTC or DOJ, to show anti-competitive effects. And so stepping back, if you're the parties, the incentive is greater than ever to make these offers, binding commitments. Obviously in the AT&T case, there was the offer of binding arbitration and no blackout, which Judge Wilkins at the DC Circuit argument credited as sort of muting the potentially anti-competitive effects. So your question was, are we going to see them as compulsory? I'll get to that in a second, but I think definitely there's just more incentive than ever to just sort of lay the groundwork for all these things that moot the government's arguments for arguing that your vertical transaction will have anti-competitive effects. I would not attempt to project what the DOJ will do over the next couple of years in terms of consent decrees. We have two tea leaves. At the DOJ, we have the CVS Aetna deal and the Cigna Express Scripts deal, which are different industries, but did have real vertical issues, and certainly were sort of the mega deals that if you were going to shine a spotlight, you might find those cleared. And then at the FTC, could be a bit of a red herring, but there actually was a deal recently, the Northrop Grumman orbital deal, Defense Department, but had real vertical issues where the FTC actually did accept a consent decree with behavioral remedies. The FTC's been vocal, just as the DOJ, about not wanting to accept behavioral remedies. Now, if you want to sort of put that in the box and say it's totally different, you could say, Defense Department focused deals have one buyer, the U.S. government. There are anomalies. There's also sort of a weird timing thing with that one, in that the consent decree came out in June when the whole commission was flipping over. So the Bureau of Competition was the one that basically issued a statement saying this is very rare, highly unusual. So you could say there's a lot of sort of weird things about that, but there is still some recent precedent from the FTC. So I'm not sure what the DOJ will do in the near term. I certainly think in the long run you could see a return to behavioral remedies, although there was really a very active flicker of that over a few periods in the Obama administration, precisely because of the deals that came forward then. So too soon to say whether the DOJ is going to back down entirely. But I think you'll see just behavioral remedies in practice, because there's, as long as the parties are willing to do them, there's really no reason not to, because you can eliminate a lot of the arguments about competitive effects.
All right, and I wanted to, Hal, you have some direct experience with the arbitration system that came under so much criticism by the DOJ in this trial. This was one of the usual ways that you would fix behaviorally a merger with problems in this industry. Can you talk a little bit about your experience? I think it was under Comcast NBCU. You were part of several arbitration cases.
Well, yeah, I was part of one. It was the Project Concord challenge, and we won it in front of the arbitrator. The arbitrator decided that our offer was closer to fair market value. There are two other cases which I would also put in the victory bag. There was a Bloomberg challenge for a channel placement or channel positioning, and Bloomberg won. They took that in front of an ALJ and won the case. And then there's another case, and unfortunately the DOJ's annual report keeps calling it an unnamed OVD. It's so frustrating. But they apparently sued, and Comcast settled with them. Now the Concord case did get appealed, and we have a fix for that when we go back and do this, and I will acknowledge that there's a gap there. But that doesn't really speak to the adjudication of the dispute per se. So I think that Macon's position here was more religious. It wasn't evidence-based. I could keep going through the program carriage decisions. I was involved in the cases against Comcast on behalf of NFL, tennis, and and Masson, which is the Baltimore Orioles. And in the NFL and Masson case, we secured a settlement in the middle of the trial, which again I'd like to, with broad carriage, I'd like to put that in the win bucket. I know it makes me sound special. At tennis, we also got to win in front of the ALJ, and that got appealed up to the DC Circuit. So I don't expect that Macon is going to come around on this, because I don't think that his opinion is evidence-based. I think it's more religious, and it's very hard to turn somebody around, who holds religious belief. But at the end of the day, I don't think it's going to be Macon's decision to make, to the extent that Congress gets around to updating the program access and program carriage rules. If you recall, these were last addressed in 1992, I think before even broadband was on the radar. And the whole reason why we needed a remedy, behavioral remedy in Comcast NBCU, was to fill a gap in protection, basically by extending the program access and program carriage rules into the broadband space. Right? So if we had updated laws that gave independent distributors and independent networks protections, we would probably see those enforced by the FCC. And so at the end of the day, I don't think it's incumbent upon me anyway to convince Macon that this is the right way forward.
Okay, well, I wanted to switch a little bit. It sounds like leaning a little bit towards that there might be slightly weaker enforcement. That's just my interpretation. I guess I'll ask. Oh, Russ.
Well, I disagree. I guess I do think that we're going to see. I don't think the DOJ is going to back down or be more cautious.
Yes, go ahead.
This is the government, and they've been pursuing these cases for many years, and decades. And I would find it surprising that because of the outcome of one case that was very fact specific, that they're going to change their approach towards the way they engage in antitrust enforcement. And if I can explain why I think so and make a prediction, the DOJ's concerns with the AT&T Time Warner combination, based on these facts alone, there's good cause for them to look at Comcast NBCU. I agree that the court reached the wrong conclusion based on the evidence that the DOJ put forth with regards to AT&T Time Warner. But if you look at the combination of AT&T Time Warner versus Comcast NBCU, the harms are so much greater. And I think Hal was speaking to some of this maybe implicitly, is that the content owned by Comcast includes broadcast stations and regional sports networks. That's far more popular programming than anything that is owned by AT&T. The market share of Comcast is 50 to 60% versus AT&T. In A markets, about 30%. And the profitability of Comcast gaining new subscribers is greater than anything that AT&T can do, because AT&T has a single network, which is for offering video, versus Comcast, who has triple play providers, so they get profits from their video, their internet, and their telephone service every time customers switch over. And I think Mandy was right in acknowledging that while AT&T, one of the reasons why AT&T succeeded was it did actually have agreed to conditions, arbitration conditions. These arbitration conditions actually were the same ones that were subject to Comcast NBCU that later were sunset. So what you have is this anomalous situation where you have AT&T subject to conditions, yet you have Comcast NBCU, who is far more powerful, not subject to any conditions. And internally we consider this the coyote is on a leash and the wolf is running free. And so I think that DOJ recognizes this fact. And I think it's indicative of the fact that they've already notified Comcast NBCU. And this is during the process of their trial against AT&T, saying that we're going to monitor your activities now that the conditions on you have been released. ACA may have been public. It's called for an investigation of Comcast, and we actually think that it's going to happen. There's good reason for them to further collect more evidence to see what is Comcast behavior now that the conditions have been released.
And I think the other thing to consider is that DOJ is also going to be watching the behavior post-merger, and you can already point to things that indicate that the DOJ was absolutely right in this case. AT&T said that they weren't going to raise prices and that they would continue to make its programming available, and that actually has not been the case. So, there's an ongoing dispute right now, and for the first time, AT&T is withholding HBO programming from a major MVPD competitor, that's Dish. And this is the first time HBO programming has been withheld from a competitor in 40 years. So I think that's fairly significant. And in terms of price increases, it wasn't long after the merger was completed that we saw AT&T raise its prices across the board. So they raised their prices on their unlimited wireless plans. They raised their administrative fee on all of their wireless customers to the tune of almost $1 billion. And it also raised its prices on its DirecTV Now service. So we've seen increase of prices. We've seen withholding of programming, and I would just think if I were Macon, I would be watching all of that too. And that probably would, incent me to, consider other remedies that could take place post-merger, even if the court, does as we're predicting the court will do. So I think that's something that to consider. And then, the other, I'm not surprised that AT&T is raising prices. I fully expected that was going to happen because I think generally the markets aren't competitive depending on, even when you're looking at different product markets in this space. So, but when you look at how much money AT&T has borrowed in order to do its last couple of transactions along with the debt that it already had, it's the most leveraged company in the world right now, $183 billion. And it's got to, increase its revenues in order to pay off that debt. So, I'm agreeing with Ross, but I'm adding to it that there are other factors that I think post-merger Macon and the DOJ team will be looking at and considering and, could come back and impact this particular case, but then also just looking forward to other cases, such as, looking at the Comcast NBCU case again and other things that could come up.
All right, well, let's move on a little bit. I wanted to ask, and one of the things, as a reporter on this, we're always interested, well, is there already an impact that we're seeing at the agencies on this? Mandy, do you think maybe you can address that in terms of, are you seeing any changes perhaps in the way that companies are dealing with the agencies or how, vice versa?
So I don't actually think so. I think when you're counseling, maybe these types of things come up as you're thinking about very critical issues 18 months out, the risk of litigation. But I think in the near term, these are all issues that anyone looking at any of these deals would spot and counsel on. Horizontal deals raise horizontal issues, big vertical deals raise big vertical issues. There's always a risk of enforcement. There's always a risk that a new administration could come in and disagree with what the past one did. So I don't think it's having a material change. There's certainly been a lot of discussion, I think, about vertical deals, and I think the bar is very closely watching, and discussing, whether they're the less flashy, the smaller deals that have interesting vertical deals, or those getting scrutiny and attention. And I wouldn't say it's not having an impact to lead one to believe that people think there's less enforcement. I think it's the opposite. I think people are assuming there's going to continue to be enforcement, but the issue here is really, at the end, do you win with a consent decree, or do you go through litigation? And all things being equal, companies hate litigation. They want certainty.
Well, let me follow up on that. Do you feel, if you're representing a company involved in the vertical issue, that you might have more leverage now in the wake of this decision?
So I think it depends. The thing about Leon's decision is it was very much focused on a bargaining leverage theory. And what Hal was just talking about, and sort of traditionally when we think about vertical deals, we think about foreclosure theory. And so part of what I think the challenge with Judge Leon's decision is, as you think about other vertical deals, we continue to look at foreclosure issues. There's no doubt that it's a helpful fact in the crux of an intense negotiation with the DOJ to say, if you litigate, you will lose. But I'm not sure that that's a deterrent right now, right? I think a lot of people thought you could say that at AT&T Time Warner when they were making the decision to go to court, and that wasn't a deterrent. What I think most people thought would probably happen, given the legal framework, happened, which is the DOJ lost. There's a appellate panel with an Obama appointee and a Clinton appointee, among others, and I don't think they seemed particularly predisposed to the government's view. So it's a threat for sure, but I think you continue to counsel companies that there's a risk of a consent decree, and if the status quo holds, then maybe you get off free with a consent decree. So I think it matters on the margins, but in the day-to-day, the same issues persist.
Does anybody else want to respond before we move on to them? Okay. I wanted to be, since we had like 2 questions that are asked in the title of this thing, we're going to get to the second one, which is essentially will video on the internet be more or less competitive? So Ross, why don't we start off with you? Question for you. How did the AT&T Time Warner decision change the competitive dynamic of the basically how the video content and distribution industry?
Sure. Well, I think most immediately, for those who believe the DOJ's case, and I can tell you from the perspective of smaller providers like my members, they do believe that as a result of AT&T, DirecTV being able to acquire content that when they negotiate with Time Warner, they're going to be charged higher prices than they otherwise would. Or at its worst case, they will not be sold that content at all. And we've already seen, as Angie mentioned, that there was a dispute over the HBO with Dish Network. I think longer term, the marketplace, we're going to see trends towards greater consolidation that are just going to be driven by business imperatives. Obviously, AT&T has become a much more formidable competitor, both in and as a result of their vertical integration, and you're going to see some firms saying that I need to bulk up in order to compete, and you're going to see others that are going to say I have to sell because I can't compete in this market anymore. And I think you've already seen it a bit with Disney and Comcast trying to acquire Fox, who wanted to sell. And I think some of these firms will take a look at what the judge decided in AT&T Time Warner, but I don't think that's going to be the factor. I don't think they're going to say, oh, look at AT&T prevailed in the court, now let's go make a deal. I think it's going to largely be driven by the business. 2 other impacts, I think, from a competitive perspective that I think has not been the focus of the actual case, AT&T Time Warner case, but I do think could be, in hindsight, more important than we think. Number 1, it's in the wireless industry. This is the first time that a major wireless carrier also owns content. How are they going to use the content in combination with the wireless business in order to become a better competitor? And what will that mean for their competitors? Is Verizon all of a sudden, if this experiment, I would call it at this point, for AT&T Wireless and Time Warner content is successful, then maybe Verizon will say, I need to own content as well. Maybe Sprint and or T-Mobile might say the same. I think it's very significant that this deal is the first time that a virtual MVPD, and I'm talking about DirecTV Now, also owns content, which is the Time Warner content. And what will that mean in the virtual MVPD marketplace? And will other virtual MVPDs be able to gain access to that content? Will other virtual MVPDs say, we need to own content? I think a lot of those things are uncertain, and we're just going to have to watch the market to see.
Okay, Angie, does your organization have a similar view? Do you see it as...
Similar, but I think, I have a slightly different point to make, and that is, I think there's an incentive and an ability when you are a major player owning a network that others have to travel over in order to be able to offer competitive service against them. And right now we're in a world where there are no net neutrality protections in the United States. And so the development of over-the-top competition that has occurred, both with the perspective of the virtual MVPDs as well as streaming services, some of whom Encompass represents, has been a critical one that's offered more choice to consumers, lower pricing, an opportunity to go more a la carte. Kind of the Chairman Kevin Martin view of the world 10 years ago was consumers should have more choice about the video programming that they want to purchase, and they should be able to do so, pick the channels, pick the programs. And we've seen a world go that looks more like that. We've had 10 million American consumers who've decided to cut the video cord over the last 8+ years. And I think that's largely in part because they've had choice. And we've had net neutrality protections up until June of this year that ensured some level of ability of a consumer to reach the programming of their desire without being blocked or throttled by the large ISPs who have an incentive to block and throttle, charge unreasonable interconnection fees. And now, with more vertical integration and owning programming, even more of an incentive to mistreat the competitors, either by favoring your own programming and or by disfavoring your competitive programming. So, I think these are the issues that really need to be carefully thought through. And our concern is that we have high dependence of the regulator who has the authority under the Communications Act, the FCC, who has stepped away from the table and has said that this can all just be done vis-a-vis antitrust authority through the FTC. And I don't know, I didn't hear any mention of open internet earlier today. It's not clear to me that there's any indication that there's consideration about what's happening in the internet space vis-a-vis competition over the internet. And yet we've had very recent reports that video is now being treated differently, and competitive video is now being treated differently post-June, when the net neutrality rules were no longer in effect. That's concerning. It's very concerning. We need regulators to be looking at what's happening on the internet, whether or not the competition that has thrived there can continue to thrive, and how the vertical integration that is occurring changes the incentives and potentially is changing the behavior. So, from our perspective, those are the things that we're tracking and following, and would like to see more development of the regulators' viewpoints.
All right, I wanted to follow up on something you said. You were mentioning that net neutrality has been struck down, and how we're in that world, and we also, unlike the cable industry, the internet broadband industry isn't governed by program access and carriage rules, of course. So what happens? Does the DOJ step in and step up its enforcement as a result?
No, DOJ is not going to be involved in the solution net neutrality, and I agree with Angie that antitrust isn't the solution to net neutrality. That's not going to be a way to. That's not the right tool. I am optimistic, however, about the prospects of net neutrality. I want to talk about two paths. One might be obvious, and the other one not so obvious. And the first one is, I think, with a new Congress, there is a prospect of getting net neutrality legislation. And the reason why I'm fairly optimistic is I do think there's a consensus on the policy. That is, general blocking and throttling should be banned or subject to some kind of per se rule, and zero rating, on the other hand, would be subjected to a standard. You could think of bad types of zero rating plans and potentially good types of plans. So long as there's a consensus on the policy, it seems to me that if you started with just the 2015 Open Internet Order and dropped it into a new source of authority, unrelated to Title II, I'd like to see that bill have a shot, because I think that you could get to a majority and support. But there's a second path to getting to net neutrality that may not be so obvious, and it's one that I'm following closely. But Senator Mark Warner, in his tech manifesto, had in this chapter at the very end called Competition, he talked about importing cable-style protections, and he was speaking about Comcast NBCU, but program access, program carriage in particular, into the tech space. And it became a little more concrete in what Representative Cecilline said during a hearing with Google this week, in which he suggested that we should have a non-discrimination standard with respect to dominant online platforms. And it occurs to me that if Congress were to authorize the FTC to enforce a non-discrimination standard against dominant online platforms, or dominant vertically integrated online platforms, depending upon the definition of an online platform, you could visualize ISPs being swept under the rug and being potential respondents in front of a new FTC forum. So I'll leave it at that.
Okay, I think this is going to be our last question. Do either one of the other two panelists who haven't talked on this particular question, Mandy or Ross, do you want to weigh in?
Just one quick observation, which is that we've been talking about how there's not really a role for the DOJ, and part of the challenge with the antitrust is these cases have like a 2-year lifespan, and, you know, then the government loses and there's, you know, perceived to be no regulation. One of the really interesting things about Judge Leon's decision is that in trying to find anti-competitive effects, he leaned, rightfully or wrongfully, but very hard on the fact that there hadn't been a history of vertical mergers of this sort leading to anti-competitive effects. So you could actually see, and this is not a short-term solution to anything, but you could see in a weird way all of this coming full circle if it looked like within the industry there was a way to ultimately show over the long run, you know, some of the anti-competitive effects that folks are suggesting may exist. That actually wouldn't necessarily be an issue for AT&T Time Warner, but it could be an issue for future cases if someone could use that as evidence. So stay tuned on whether this, you know, cycle continues with future vertical consolidation, because I think it's the story's not yet over. Of course, if the new administration accepts behavioral remedies, then we're back to this is the challenge with Judge Leon's finding, a regulated environment in which you're not going to naturally find those anti-competitive effects because of the layer of regulation.
Can I just look, I mean, we are video providers that I represent, and we are broadband providers, and look, smaller ISPs, I think applies to the larger industry, have been acting consistent with the open internet rules for years. Don't have the incentive, don't have the market power to harm the open internet. And, you know, it's just bad for business to do so. And although the net neutrality rules themselves and the Title II rules have been rescinded, we still have the transparency disclosures in place, which require any ISP to say what it's actually doing with regards to blocking, throttling, and prioritization, which empowers consumers to say, if I don't like it, I can go to my competitor who's not doing that. And I think that that is a very big, important part of the remaining rules. So for these reasons, I don't see ISPs really acting to harm the openness of the internet. You know, but certainly I think as if we had rogue actors out there, you know, the DOJ, the FTC is perfectly capable of dealing with it. Notwithstanding that, I note that the industry already is in support of net neutrality rules. They've called on Congress to adopt bright line rules, no blocking, no throttling, no prioritization. I personally see that as being capable of addressing any of the concerns I think we've spoken about in the last 5 minutes.
If I could respond to just 2 points about the open internet. One, I do agree that it's likely this Congress is going to take it up and look at it. I mean, you have, while Republicans are still in control of the Senate, I would note the Senate passed the CRA. 3 Republicans voted for it. They think net neutrality is important enough, and not surprisingly, because 80% of Americans support net neutrality and would like to see there to be just rules, basic rules in place. So I fully expect that. And, you know, unfortunately, and I'm not saying this about your companies that you represent, Ross, but, you know, a large percentage of Americans, a majority of Americans only have one choice, and their choice is a large ISP. And that have different incentives and capabilities, things that DOJ and FCC have looked at in the past and have said, yes, this is a problem. This is with respect to Comcast Time Warner Cable, for instance. So addressing kind of the basic regulatory issues on open internet and doing so via a congressional act is something that I would fully expect to see this Congress take up. And I would not be shocked if the very first thing that we see you know, some of the Democrats do is introduce a very clean bill that would reinstate the 2015 order and its rules. I think that that's a great place to start. They already have a Senate that passed that just recently this year. So we encourage that and look forward to working with the Congress and our fellow members on this panel here to ensure that we have net neutrality protections in the United States that are strong, just as we have advocates in the government who tell other countries that they need to have net neutrality protections in their countries.
All right, I think do we have time for questions? 2 questions. 2 questions, okay, from the audience, since we're running a little bit late. Do I see a hand up?
We answered them all.
No questions? All right, well, thank you very much, panel.
Thank you.
That's what we get to do. Appreciate it.